For many officers, and what the officers should know is going to be quite a shock to them, the fact that almost every traffic law in the country is not compliant with the law that it purports to be. All traffic laws in the United States, adjudication standards, vehicle codes set by the city, state, or county, doesn't matter who, or the fines even applied, are established in federal law, and every single thing a city does, or a county does, or a traffic engineer does is governed by the standards of the federal law. And there's one thing in the federal law on speed limits in particular, but it actually applies to any law affecting the traffic or behavior. And it's called the basic speed law. In some states it was called prima facie, but in every state they had some version of it. Regardless of the language, the effect was the same. If a reasonable person driving safe for the conditions then present was not a violation of the law. And this was prior electronic signal timing or right turn cameras or stop sign cameras. But the basic in the federal law is a person acting responsibly and doing due caution and safe for the conditions then present is not a violation of any law. So the speed limit, as we know it today, is a fiction created by the National Highway Traffic Safety Administration, because the original application of the posted number, which is the posted speed, and we'll show you a sign here shortly what it looks like. The posted speed was recommended upper end of what the local people, the consensus people using the road, had found safer conditions. And the posted speed was the guidance speed, as what the higher end of what would be recommended travel speed is for that particular section of roadway. The term speed limit came in as an actual definitive defined in excess of during the national speed limit during the energy crisis, and it was brought in as a fuel saving measure, which said if you're going past that, you're violating an environmental law, not a safety law. But even so, back when they were doing the speed limits, and the nomenclature during this period was speed limit because of that particular clause, the safest speed for a road to be posted using the term speed limit was the 85th percentile, which in no case was a hockey stick, we're going faster than that, was unsafe. In fact, most speed limits, according to the Federal Highway Administration, at the time, found that 5 to 10 miles an hour, most speed limits were posted 5 to 10 miles an hour below the safest speed and up to 15 miles an hour below the safest speed in urban conditions. When the national speed limit was repealed in 1995, the law should have gone back to posted speed as the speed limit based on an engineering study. That didn't happen. The people in charge kept the speed limit as a definitive excess of as unsafe when there's no foundation anywhere in engineering. In any study ever done I've ever seen, found that to be in excess and unsafe speed. So the entire definition and application has been just simply not true, any way, shape, or form. There are applications for speed limits. Let's say you're going across a steel bridge where an accident above a certain speed would cause catastrophic damage. That would be a good application of a speed limit. But on a general road, you should do the posted speed for the optimal upper end of what the safer conditions have been found by the consensus of the local people by their actions. It's the duty of the engineer to quantify all the conditions on that roadway and make sure that the conditions are set for the safe operation at those speeds. And the officer is supposed to know what those findings look like and understand what the range of safe speeds are for that road. Of course, any activities that are unsafe for conditions in present are subject to enforcement. But you see, the irony of it is not just in excess of the speed limit. If it's snow or you're icy out or someone's driving too fast for conditions, the officer has the right to pull somebody over for making a judgment call that they're driving unsafely. But when you think about it, prior to our electronic enforcement things and all the laws that we've, even on stop signs, see, the stop sign warrant originally required not to put a stop sign in unless there's a warrant to justify its use, but more importantly, it said to use a yield sign first option and to go to a stop sign as the last option. So even if you're doing a right turn on red or right turn on stop, if it's a reasonable and safe action by the motorist, there's no justification in law to issue a ticket because it's a technical violation of the language. It violates the actual spirit of the federal requirement that it be an actual unsafe act. One of the things that became early on, in fact it was practiced in the early 70s up until then, if you had a large number of violations or citations going on at a particular location, the traffic engineers were supposed to review it because there's an indication of something that's catching these motorists out, and it's usually an engineering defect. So if you have something in your area that you think is causing a large number of problems, then you should put a note into traffic engineering to say, hey, we've got something going on here, why don't you take a look at it? It shouldn't be a source for citation writing as your little cherry spot. It should be as a good citizen to make sure that if there's something going on, you report it to the proper chain of command to make sure that someone takes a look at it to see what can be done about it.